Hello friends, in the series on the income tax cases, today we will discuss an issue that whether section 13 will be considered for those assessees which are being notified under section 1023C clause 4. In other words, if an assessee makes a violation of section 13, so whether in that case the exemption under section 1023C clause 4 can be denied to the assessee. This issue has been taken by Chennai ITAT B bench in the case of income tax officer exemption versus the Theosophical Society. This case has been reported in 114 ITR Tribunal at page number 282, and this matter has been decided by Chennai ITAT B bench on 10th June 2024. The present case relates to the assessment year 14-15. The assessee was notified under section 1023C clause 4 since 1977-78, and the assessee was also registered under section 12A clause A since 12th December 1975. During the assessment year 14-15, when the assessment proceedings were going on, the assessing officer observed that there are two substantial donors. Those two substantial donors were given some premises of the assessee at very minimal maintenance charges. The assessing officer was of the considered view that in the present case, section 13 subsection 1 clause C clause II is attracted, which says that if any income or property is applied for the benefit of those persons which are referred in subsection 3 of section 13, then the benefit of section 11 should not be given to the assessee. Since in the present case the assessee was claiming the benefit of clause 2 of explanation to section 11, and the assessing officer was of the view that the assessee has breached the provisions of section 13 because some premises were given on very minimal maintenance charges, so he invoked section 13 and denied the exemption of section 11 to the assessee. The assessee was contesting the issue on the ground that section 13 is not applicable to all those funds which are notified under section 1023C clause 4. But the assessing officer go ahead with the denial of exemption under section 11 and some other disallowances also. When this matter came to the CIT appeal gave relief to the assessee, so the revenue moved to the tribunal. When the tribunal heard the matter, first of all the tribunal said that in the present case, it is a debatable issue that whether the substantial donors are the interested persons according to section 13 subsection 1 clause C clause II. Secondly, the tribunal observed that as per the evidences filed by the assessee, whatever the lodging facilities has been given to the substantial donors, this facility has been given for theosophical work of the assessee, and those substantial donors were providing their services without taking any remuneration from the assessee. So practically section 13 is not applicable to them. The tribunal further said that even if it is assumed that they are given some services without adequate consideration, then in that case also Central Board of Direct Taxes Circular number 557 dated 19th March 1990 clearly says that section 13 is not applicable to the funds which are notified under section 1023C clause 4. The tribunal also relied on the judgment of Virendra Singh Memorial Shiksha Samiti, which has been decided in 2016 and which has been reported in 35 SOT at page number 1, and that case was decided by Lucknow ITAT. In that case, it was also held that section 13 is not applicable for the funds or institutions which are notified under section 1023C clause 4. So, the tribunal upheld the order of the CIT appeal allowing the exemption under section 11. At the end of this video, once again I am repeating the name of the case. The name of the case is Income Tax Officer Exemptions versus the Theosophical Society, and this case has been reported in 114 ITR Tribunal at page number 282, and the matter has been decided by Chennai ITAT B bench on 11th June 2024. Thank you, friends.